Welcome to another episode of the 39A podcast. This is Devika Prasad from Project 39A. We are a criminal justice program based out of the National Law University in Delhi. For this episode, we are in conversation with Babloo Loitongbam and Henri Tiphagne to commemorate the UN International Day in support of victims of torture. 26th June is the day in 1987 when the UN Convention Against Torture came into effect. Today is a sober reminder that 24 years after signing the UN Convention in 1997, the government of India has still not ratified it and brought in a strong domestic torture prevention law. With this in mind, it's heartening to introduce our two guests and have the opportunity to talk about their work in supporting torture survivors and their families. Babloo is the director of Human Rights Alert, an NGO based in Manipur. He has been documenting human rights violations in the Northeast, organizing victims, and opening up access to human rights protection mechanisms. Henri is one of the founders of People's Watch, based in Tamil Nadu. People's Watch documents human rights violations and provides legal representation and rehabilitation avenues to those affected. From 2006 to 2008, he was engaged in a national project with partners in 9 states, monitoring and intervening in cases of police torture. Babloo and Henri, welcome to the podcast. Thanks very much for joining us today. So, Henri and Babloo, I'd like to start the conversation by asking you, in your extensive work, especially in dealing with cases of torture, how would you describe the nature of torture and the circumstances in which it most often occurs in your state?
Thank you for inviting us for this very important conversation. Well, in my particular context in Manipur, torture happened for a long time on petty criminals, poor people, but it had taken a much more diabolic proportion when it was used systematically as part of the counterinsurgency operations. So people who are suspected to be involved with insurgency or what we call generally in underground activities, there was a kind of an acceptance that they should be tortured and it is okay to torture them. In fact, it is considered as nationalistic or patriotic for the law enforcement officials and the military to torture them. I still remember a young man who was suspected to be supporting the insurgent when I was quite new to this documentation of torture. His name was Pranam Singh. We went and documented his case, and his intestine was dangling outside because the military have put a stick into his anus and destroyed the entire intestine, and he has to undergo operation. He was completely pale struggling to survive. So this picture remained with me for a long time, even as we continue the work for the next 20 years and more. So in the counterinsurgency context, torture has been systematically used to break the whatever the resistance, the spirit, what is construed as anti-national activities. So it became a much more systematic work that is perpetrated by the state with a political objective.
And Henri, if you'd like to also answer that question.
Thank you, Devika, for this opportunity of a discussion with you and Babloo. My own personal understanding of torture through a definition came much, much later. My understanding of torture started with what we saw in the 70s in my part of the country, where the so-called anti-Naxalite movement was to be crushed. And to crush that, any amount of police violence, various forms of torture were generally permitted and accepted by the public. And this is what was the basis of very organized torture that took place. It was much later that a very careful understanding of the definition, particularly the why of torture being not only for punishment, not only for obtaining confession, but also for intimidating and coercion for any reason based on discrimination of any kind started entering our system. And by that time, I think for me, it was already 1995, and I saw it happening. So-called caste riots of the early 90s in southern Tamil Nadu, where we found that on the basis of caste, there was a very clear discrimination. And all attacks of the dominant caste were tolerated by superior officers of the state, whereas there was a clear discrimination against the Dalit populations, the victims who came from there, and there was torture that was taking place on them by the police, which had its origin in discrimination and caste discrimination. And later we saw this developing, and that was the whole spate of incidents during where the caste riots were taking place in Tamil Nadu. Then after we learned about torture in a little more significant manner when we were in the 1990, early 90s, where we saw the special task force created by the government of Tamil Nadu and Pondicherry, and incidentally headed by the same police officer who was in the anti-Naxalite wing that I referred earlier. In their attempt to catch Veerappan, all forms of torture were used. So the special task force was another event when everybody was able to see what was taking place. And thereafter, of course, all of you know that this is a regular, routine, everyday affair. I had occasion between 2006 and 8 to work in about 9 states with a number of organizations and work in 47 districts. We expanded the results of what we saw in the field. Our results showed that 1.8 million people fell victim to all forms of torture in the country, in our police station.
That's a very sobering reality, Henry, that you shared. On this question of whether it is routine, Babloo, I wanted to ask you if you found, the same reality in Manipur.
Of course, as I was also describing earlier, the torture have been used primarily to break the insurgency or the armed rebellion. And the instrument that is used is the Armed Forces Special Powers Act, which provides impunity to the security forces. But once that phenomena of impunity sets in to the institutions, the police, the administration, the medical professionals, the police also systematically indulging in torture. So it was a very routine exercise. There are certain torture centers that were designated inside the military camps, but also in what we call the joint interrogation centers, where both the state as well as central security forces, as well as the intelligence people would torture suspected insurgents to extract what is called operational intelligence. Interestingly, earlier, even in the Armed Forces Special Powers Act operation, the military was expected to hand over the people who are arrested by them with least possible delay to the police stations. But however, there was a change when counterinsurgency intensified in 2001, following an SLP by the army to the Supreme Court. They have got an order specifying that the military is authorized to gather what they call operational intelligence, unlike substantive intelligence, which is basically the work of the investigator. So giving military the authority to extract operational intelligence from suspected insurgents has given them a lot of leeway for suspected insurgents to be detained, tortured, and extract those intelligence. The problem is once you allow these kind of exceptional laws to operate, who is a suspected insurgent is a very, what you call, subjective question. So the people who can be detained and subjected to this kind of torture, that definition keep on expanding. It doesn't limit, the nature of power being what it is, it keep on expanding to other people. So if the police wants to settle score with somebody who they are not happy with, or if they are paid by a certain vested interest to torture someone, then all kinds of these draconian laws are used against people. And because of that permissiveness and because of that impunity, they can exercise this quite liberally without any fear of law setting in. I mean, we have not just the Armed Forces Special Powers Act, but if you look at the Unlawful Activities Prevention Act, Manipur is such a small state with not even 1% of India's population. We are not even 0.5% of India's population. I think we are 0.4% of India's population. But if you look at the number of people detained under Unlawful Activities Prevention Act, we are at least 34%. That's the latest figure, but at some point it was even more than 60% of the Unlawful Activities Prevention Act detainee. And when once you are detained under this kind of special laws, torture has become quite routine. And therefore, the problem is when you create this kind of state of exception, it gradually becomes the rule. And once you give police and security forces this kind of impunity, it doesn't confine to specifically insurgents or suspected insurgents, but it slowly spreads to the rest of the population. The caste dynamics that Henri have described is probably not so stark as we in our context, but ethnicity is definitely an issue where, you know, if you belong to the dominant ethnic community, then perhaps you have friends and relatives and people that you know within the power structure. But if you come from a small tribe with very little access to power, I think that your vulnerability also increases.
So just the way Babloo has pointed us to the fact that social identity certainly plays a part in who are the victims of torture, I'd like to ask you, Henri, in your context in Tamil Nadu, who are the victims of torture?
I really would like to follow from where Babloo left on the question of vulnerability. And when we look at the vulnerability question, we see that it is usually, in general, if you were to speak, the powerless sections of society. And when I say powerless sections of society, it is not only in terms of caste, it is also in all other forms of poor people, homeless people. If you are poor, you are more vulnerable to be subject to torture. There are definite results that have come out of our engagements which show that the scheduled castes, Dalits in general, Adivasis in particular, and these days also Muslim sections of population, in addition to generally poorer sections, are the most vulnerable to torture. And in particular, mention has to be made, Devika, to what are known as denotified tribes. These are remnants of the old British Criminal Tribes Act of 1871, which was repealed later, and then, of course, has been repealed in 1949, and then brought again through the Habitual Offenders Act, where people who belong to certain communities which are denotified tribes are then specially picked up by the police for subjecting them to torture in relation to criminal cases which are undetected. So these are communities which are located in different parts of the state, and the police know where they live, and all that they do is subject them to brutal torture, ask them to give out confessions on the basis of which hundreds of cases are registered against them. And it's a sad reality because convictions are very, very rare. And therefore, families cannot live together because they are born into a community which is a denotified tribe, and therefore at the hand of the police for torture. So it is not only Dalits, not only Adivasis, denotified tribes, Muslim populations, and generally the powerless in the state who are vulnerable to various forms of torture that we have spoken of.
I'd like now to understand a little bit better in terms of the strategies that you both adopted in this very complex and difficult work on torture prevention and anti-torture. How have documentation on one hand and litigation or legal interventions integrated and complemented each other. And especially to highlight, where does documentation stand in this? I mean, is it a sort of precursor to effective litigation? Babloo, if you can share your thoughts.
Devika, I think documentation is the key. It is the first step for the rest of the journey that we need to work along with the torture survivors. Getting the narrative from the survivor himself, documenting it, putting it down in black and white. Documentation in the sense of, photographing his or her injury or the marks that is left, the telltale signs of torture that is physically visible, but also documentation in terms of, a medical examination and getting a doctor to testify the reality of torture. Very often, this is the problem. There is a hesitation from the medical community, also, particularly in a very charged environment like what we see in Manipur, to say that these are the result of torture. Nobody wants to get entangled into medical legal cases. So these are some of the challenges we face. But again, without proper documentation, it is very, very difficult to get into litigation. Honestly, there is also a very deep sense of reluctance from the side of the lower judiciary or the police themselves to file an FIR. There is a need for a very clear law in the country. Efforts were made, but it's never happening to define torture specifically as a crime. We are all now using grievous hurts and all this kind of very general legal provisions to take up the torture litigation. And honestly, we have no case to cite as a successful fight against torture in terms of getting a good judgment from the court. Sometimes, quasi-judicial bodies like the Human Rights Commission, the State Human Rights Commission, are much more responsive to it. But in any case, it is important. I mean, documentation is not just a statement of the victims, but also our effort to use the system and the systems taking cognizance of it. That also needs to be documented. But honestly, it's a very frustrating experience so far, particularly in the context of Manipur, because there is a very, there's a strong kind of belief that if people are of doubtful character or criminals, there is also a sense among the institutions, people who are manning the institutions, that torture is okay. We have more success if there is debt resulting out of torture. If it is a custodial debt, then there is a lot more. It is much more easier to document in the sense the mobilization of the society and the media, and also as a result of that, the lower judiciary or the police is easier that way. Whereas sometimes in the context of the conflict in Manipur, where there is so many violence, sometimes people who walk out of the police station or the army camps alive consider themselves as lucky because at least they are alive. The other challenge of documentation and litigation is that people suffer tremendous amount of post-traumatic stress. And for people who have gone through this traumatic experience of being smashed, it's not just the physical destruction, but your whole self-esteem is also very badly destroyed. So this whole process of how this survivor, the psychological state of this person has to gradually move from this survivor to a litigant is a huge process. And very often we cannot come to that extent. A recovery and a sense that, yes, I am a human being and therefore I have human rights. And as a human rights holder, we need to claim that right by using the system. It's a huge process, and particularly because we don't have very good example to set or precedents to show to these victims or the survivors that yes, we can go back, fight back, and it is our basic human rights. It is very difficult to sustain this, and very often in this process, people just cave in and say, forget it, whatever happened have happened. Let me get along with life. So litigation for torture is still a big challenge that we face as human rights activists in the context that we find ourselves.
Thank you, Babloo, for sharing so deeply about the intricacies and the frustrations and challenges of working on both documentation and litigation in the context of Manipur. Henri, if I can ask you to share your thoughts on the complement and the challenges implicit in documenting and intervening in torture cases.
I'm really overwhelmed by something which I need to say because towards the run-up of this year's 26th of June happens to be on the 22nd and 23rd, the day when the father and the son from Satankulam in Tuticorin district of Tamil Nadu were tortured in police custody, were sent for medical examination with blood dripping. Their dhotis had to be changed thrice. And in spite of it, the medical examination was fit for remand. Brought before the judicial magistrate who was able to physically see them and still remanded them to judicial custody in offences which were less than 7 years punishment, contrary to the Arnish Kumar judgment. And when they went into jail, initially the jail officer refused admission because of their health condition. And then on a telephone call from the jail superintendent, admitted them in the sub-jail. And they died subsequently 2 days later on 22nd and 23rd. This is what has happened recently. And it's very important, therefore, for us to see that documentation starts for all of us in fact-finding missions that we have undertaken. And gradually over the years, we have learned, Devika, that we need medical professionals to accompany us, and particularly forensic medicine experts to travel with us. And it is without them, the fight against torture becomes incomplete. And the more we went into documentation, we realized that if we want the true version, then we needed also psychologists with us who are able to spend time with the survivor in order that the best version, closer version, which will generate more evidence, is available with us. Sometimes these look very silly to hold the hand of the survivor. And when we hold, and the survivor knows that we are holding their hand, they are willing to stand this long turmoil of prosecution, trial that they will have to undergo for many years. So that is something that I thought is important for us to know. Another strategy that we used were public hearings. And public hearings helped us. I still would remember and wish to narrate what happened in a village called Sankarlingapuram, where after the elections cast enmity between the so-called dominant caste and the Dalit village. There were protests by the Dalits. A policeman died in the process, and therefore the higher police officials wanted to teach a lesson to this village. They came, they attacked the entire village, and people had to run helter-skelter, and 189 of them were charged with murder. 189. Not a single leader could enter. It was a public hearing that was held there, where later we worked with the community for a long time, and thereafter we were able to ensure that 45 lakh worth property which was damaged was compensated only because of a public hearing report. And in the prosecution, excepting 11 persons, the others were discharged, and the 11 were finally acquitted by the trial court. Now, these are possible through this strategy of public hearings. Not that every public hearing is successful like this. No, I don't want to create that impression. But the fact that public hearings are held is giving a visibility on one side to the issue. The state is humbled in some occasions because the report goes against them. And judicial commissions, which are doing parallel work, are forced to come closer to truth because they know there is a report which is already out. And we can narrate the Paramakudi killings that took place in Tamil Nadu, or the famous Seshashalam forest killings of 20 Tamils in the year 2015 that took place, which also came out with a lot of documentation. So documentation through fact findings as well as public hearings is important. But the participation of victims is what, or the survivors is what strengthens us in the process. And these are not magics that we had in our hand. We learned this by experience. We learned this by doing mistakes with the lives of several survivors. And therefore, from the beginning, always to ensure that the family of the survivor stands with us, the community of the survivor stands with us, and the more we have their support, capacity of the survivor to withstand whole process of access to justice is becoming better. The third strategy that we used was working with children of survivors, because it is these children who will need to support the parents, because in every such case, we know it is a long run. They have to be ready for the marathon. And to prepare them for the marathon, the children were the best. And I can tell you in confidence, our work among these children has led to many of these children of parents who died in custody, who died in police custody. Their son is a lawyer today working among Adivasis, because we accompanied the child, we accompanied him as a young man, and today he's an independent person, also committed to the same cause. We have further lawyers, several lawyers who are working with us, teachers who are working in different schools, who are all children of people who died in custody or were tortured in custody in the STF violence that I spoke and other forms of violence. The last is our rehabilitation. My lessons in rehabilitation actually come from one of the torture survivors, where her husband was killed in custody. The eldest son is the one who was a lawyer I mentioned. The youngest son is today working as a social worker in our office. But what is most important in the process is that she taught me that all these things that happen in court are not what is important. That I have time to listen to her, to listen to the different pains that this torture will cause her, not for 1 month, not for 1 year, not for 5 years, not for 10 years, but for lifetime. And that lesson was difficult for me as a lawyer to understand. And the last strategy we have used, which is of late, is the use of the Right to Information Act. Fighting impunity is not only documentation and proper litigation, but supporting this documentation, litigation in various forms, including the use of the RTI, which should not be forgotten these days. I think these are important lessons that we have learned over the years, but our teachers have always been the survivors. And they allowed us the luxury of interfering with their very difficult lives to learn these precious lessons.
Thank you, Henri. It's really something to take away that all of us who do this work, who are advocating for torture prevention, our teachers are the survivors. Babloo, if you can share your experiences and work on rehabilitation and addressing trauma, as Henri reminds us that addressing trauma is just as important as the legal fight and documentation.
Absolutely, Devika. Yeah. When Henri was narrating this story, I was also reminded of one successful case where the military personnel were prosecuted by the army's own court of inquiry. This was an incident of rape of a woman. Her name was Ahanjaubi. I mean, she was become a hero after that. So I am taking the liberty of mentioning her name. Where in an army operation, her husband was the Chowkidar of the blind school. And in an early morning army operation, she was raped in front of our own son, who was a handicapped child. This has evoked the anger of the people to such an extent, and there was such furious people's mobilization and protest. The army was forced to constitute a court of inquiry, and the level of solidarity that the people showed to this family. There was one particular organization, women's organization called All Manipur Women's Voluntary Organization. They took turns to live with the family and support the family. And in the army summary court of inquiry, testimonies were given. People, really encouraged her, and the whole community was mobilized. And so clear evidence was laid out, and two of these rapists were convicted. So this was one of the rarest of the rare cases where there was a conviction. And this was possible because of the people's solidarity, people standing firmly with the victim, and therefore they, from survivors, he became basically a fighter and a hero in front of the people. So that process also is one where you rather than shame, you become a harbinger of justice. And that transformation is what we also try to do when we organize the families of the victims of extrajudicial execution with APSFA, with this sanction for killing, and the level of impunity. It was very difficult to get justice in the normal course of event. What we do in the court is a small part of the whole journey for justice. To rekindle life, I think that is a much more wider community process that has to take place. As Henry was also saying, putting out their trauma in significant way in front of the tribunals that are being constituted, people's tribunals that are being constituted, are also very cathartic for these people. Much more than that, if these victims can come together and find a soldier to cry and vent out their trauma together, as they say, sorrow share is sorrow half, joy share is joy double. It has a certain healing power, and if there is a direction in which we can all move together in solidarity toward higher goal, rather than just killing ourselves in this revenge motive, if we can come up to a larger vision which goes above and beyond the cycle of violence to the process of justice, that is what we have been trying to do with the families of extrajudicial execution. And we find that now from isolated, victimized, completely disempowered women, they are now the harbinger of justice. Because of their intervention, because of their advocacy, because of their litigation in the Supreme Court on this 1,528 cases, they are now seen by the society also as very powerful agency rather than victims. Rehabilitation is not just clinical thing that happen in isolated clinic, but it's also a social process by which we have come into terms with reality and try to fight for justice using lawful and legitimate ways. And to that extent, I think the human rights framework becomes a very useful strategy for us to adopt and move forward. And in healing oneself, we are also trying to fight the structural injustices with which they were victimized. It's not just an individual journey, but it's also a process for justice for the larger society. And it isn't also an opportunity for the state to correct itself. And good judges, I think, plays a very critical role in bringing about this.
Thank you, Babloo, especially for, I think, really drawing that connection between the strength and empowerment that comes to victim survivors in this fight. Henry, if you'd like to just share any last thoughts on the way forward as you see it, and especially, the importance of ratification of CAT. How do you see that? How do you think it can happen?
Before getting into that very specific question, Devika, I also wanted to say that the costs of such documentation is difficult. It's very painful. Fact findings in cases of torture are risky. And I want to narrate very briefly a fact that in a training program, 5 activists were asked to do a 2-day fact finding of a case of a Dalit boy who was tortured in police custody. This resulted in a false case registered against them. The 5 of them being remanded to judicial custody, kept in the women's jail and the male jail for 9 days, signing a condition bail for another 15 days. And then this happened in 2010. 2018, their charge sheet was finally quashed, in which happened in the High Court here. The NHRC had a report the same month almost, and still had ensured that the compensation they ordered was only in 2018. So there is a cost to be paid for even undertaking fact findings. Having said this, I think it is important to understand that in these litigations, though sometimes we don't fully succeed, we succeed in establishing standards, and it takes time. In my lifetime, I could never imagine that I would never ever have an opportunity of an activist, of a survivor's dependent being able, or a person who had died in custody, for the family members to be able to see the body officially on the postmortem table. And this has taken me at least 40 years to see that we get a court order saying the postmortem will not open without the family members having access to the body, taking photographs of the body, turning the body. Then once the postmortem is over, the report of the postmortem together with the videotape of the postmortem should be handed over to the family and the body maintained in the mortuary, giving them sufficient time to decide whether they need, after studying the postmortem report, a second postmortem or not. Now, this takes time. So establishing standards has also become a very important process in this whole question of litigation. It is our collective fight across the country, Babloo, in that part of the country we hear that led to the executive magistrate inquiry earlier of in custodial deaths, which have now become a judicial magistrate inquiry. And if it was not for a judicial magistrate inquiry in the recent Satangulam case, we would have never been able to catch hold of the judicial magistrate who has failed, the doctor who has failed, etc. Now, this whole very difficult question for the country, not for us, for the country is whether ratification should be done or not. And I don't understand what their difficulties are. The law is there, well settled by the various courts of our country, and every 6 months there are new standards in relation to torture that our Supreme Courts and High Courts are coming up with. So coming up with a law is in reality should not be a difficult thing. It is only the resistance that this big figure I mentioned, 1.8 million cases a year, is what is frightening them. That is something which is really frightening them, because that culture of violence, non-accountability of the law enforcement officials that we have in the country, and mechanisms that don't lead to such accountability processes, in spite of the demand for a police act to be amended, the demand for a state complaints authority, a district police complaint authority to be established, etc., etc., etc. In spite of all that, that is what is making it difficult for the government to say yes, and any government for that matter. It is very ironical that some people who serve as law ministers come in the next tenure of the next government and say CAT has to be ratified. So we need both the domestic law coming up as well as the declaration, the ratification of a convention signed at the instance of the NHRC in the year 1997. And therefore, today is the time for the new chair of the NHRC to demand from this government that the ratification should urgently take place and need not wait till the law comes, and the law should follow immediately thereafter. And the law will set a number of procedural matters, not the law on torture. The law on torture in our country is there in bits and pieces, but the procedural aspects, as has been detailed, done under the SC/ST Prevention of Atrocities Act and rules, that is what we require here to ensure victim protection. Witness protection is also part and parcel of this whole package of a domestic law that we envisage to fight torture. And that is the urgent call of the day. And I'm sure we are speaking on behalf of a number of victims of torture. Nearly, our figures show 71% of people refuse to speak about torture. And they're very prudent, because they know if they speak about torture, the repercussions are very, very difficult. So when there is and for the legal services authority in our country, which are managed by judges of the lower courts, judges at the district courts, judges at the high courts, judges of the Supreme Court, to suo moto come forward and say every case of torture will be taken by the district legal services authority. These are things that can be done. We are not talking about things that cannot be done. And I think that is what we would like to demand on this day of the UN Day of Solidarity with Victims of Torture. Not only ratification, not only law, but also access to justice through the legal services authority at different levels, to make sure that that person has somebody who will rush to her or his rescue the moment he or she has suffered torture.
Taking from the points that you both have shared, you remind us that torture is routine in India across contexts, that victims face huge blocks in seeking redress through the criminal justice system, and that we need legal reform in tandem with fundamental changes to the justice system to even begin to address these. Thank you both, Babloo and Henri, for sharing your perspectives with us today. Hearing about your support to victims has been such a fitting way for us to mark this International Day. To all of our listeners, thank you for joining us for this episode, and we hope you'll keep listening in.